Council of Ministers. Council of Ministers are both for the certain union territory. This excluded from the preview of the procedure under Article 360 to be done by single majority. Single majority. So 39. In case of local legislature of the Council of Ministers or the Council of Ministers, Council of Ministers are both for certain union territories. Some articles are mentioned at this, which requires special majority to be amended. Some articles 54, 55, 73, 162, 124 required to be amended by special majority under ratification by half of the state. 15. 7 President. Case 30. 67. Which requires special majority to be amended. 50, 55, 73, 162, 100, 124, 147. In the case of deadlock with regard to passage of the ordinary bill, joint sitting of the two houses may be summoned. An amendment bill can be never passed by the joint sitting. Passed by the joint sitting. Amendment bill can never passed by the joint sitting. Must be passed by both houses separately. Passed by joint sitting. By passed by both houses separately. This passage of ordinary passes through three stages. In the first stage, the bill is introduced in the house, but no discussion takes place. In the second house, after consideration, the bill is discussed clause by clause. In third stage, after general discussion of the bill, finally passed after its passage in one house, sent to other house for its consideration. Regard to passage of ordinary bill, a joint sitting of the two houses may be summoned. An amendment bill can be never passed by joint sittings. Must be passed one house separately, but the passage of ordinary bill passes through three stages. First stage, bill is introduced in the House, but no discussion takes place. Second stage, after the bill is discussed clause by discussion takes place. Second stage, after consideration, the bill is discussed clause by general discussion of the bill. It is finally passed. Passes in one house is sent to other house for consideration. No discussion takes place. In the second stage, after consideration, the bill discussed. The first stage, bill is introduced in the house, but no discussion takes place. Second stage, after consideration of the bill is discussed. Consideration the bill is discussed. Bill is discussed clause by clause. First is general discussion. Actually, amendment bill Legislative Council 169 to 39 creation of local legislature. Creation of local legislature council of minister of both for certain union territory and 368 to be done by single majority. Under Article 368 to be done by single majority. Single majority. 39 to 11 abolition of creation of legislative councils. The council of minister are both the certain union territories. Some articles are mentioned in Article 368. Some articles are mentioned. Article 368, which requires special majority to be amended. and special majority ratification by half of state. Article 54 election president 55p 73 162 73 73 70 124 162 governor 73 124 Supreme Court 147 Counter 214 High Court 231 241 245 245 55 all are required to be amended special majority and ratification by half of the state. Special majority, non-alignment. Not a KD. Actually, non-alignment movement will remain relevant to the hostile various military organizations and with poverty and poverty and exploitative systems at the international level. In the current unipolar world, bipolar no unipolar world, non-alignment movement. ଆମର ନାମ ସେମିତି ନିରପେକ୍ଷ remain relevant due to the various military organizations and weapons of mass destruction, poverty and exploitative systems. 24th Amendment. Parliament is the supreme. It can amend Constitution. Fundamental rights. Procedure for amending the Indian Constitution is neither flexible nor rigid, but a combination of both. 68 in part excess of the Constitution deals with the power of the Parliament to amend the Constitution and in procedure. The Parliament may, in the exercise of its prior to the Golokanath case, Supreme Court maintained that fundamental rights were also amendable. The case ruled that the fundamental rights were transcendental in nature. Parliament cannot abridge or take away any fundamental rights. Supreme Court maintained that fundamental rights are also amendable. To Goloknath case. The case ruled that fundamental rights were transcendental, abridged or take away any fundamental rights. Parliament may, in the exercise its constitutional power, amended by partition, variation or repeal any provision, addition, variation or repeal any provision of the Constitution in accordance with the procedure laid down. Prior to Goloknath case, Supreme Court maintained the fundamental rights were also amendable. Fundamental rights were transcendental in nature. Abridge. Reacting to this judgment, Supreme Court of Parliament through 24th Amendment Act 1971 brought certain changes to the amending ability of the fundamental rights. Amendment Act 1971 Article 368 declared that the Parliament has the power to abridge or take away any of the fundamental rights under Article 368. Such an act will not be law under the meaningful Article 13. Not judicial act. Judicial. Not Article 13. Judiciary movement. Move to the Supreme Court. Supreme Court upheld the validity of 24th Amendment Act and stated that the Parliament empowered the abridge or take away any fundamental rights, but at the same time laid down the new doctrine of the basic structure of the Constitution. Laid down new doctrine of basic structure of the Constitution. That is, maybe 24th Amendment enhanced the power of Parliament to amend the fundamental rights. Amend the fundamental rights.